Thank you. I'd like to call the first meeting of the Rules and City Government Committee to order. For the record, all participants, all Aldermen, Alderman Arnett and Alderman Savage are in attendance. I also see Alderwoman Tierney, as well as City Attorney Leonard and Mr. Manasseh from the Planning Department. And I see Dr. Nash also here. I'll entertain a motion to approve the agenda.
So moved.
Second.
Okay, all in favor of approving the agenda as written, please say aye.
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 Okay, next item is approval of the minutes from our December meeting.
Move approval of the minutes.
Second.
Okay, all in favor, please say aye.
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 Okay, first item on our agenda, and help me, which piece of legislation is first? Since my agenda. 1919. It's an old piece of legislation. Adequate public facilities. Alderman Arnett, I think this is your legislation. I know we have several people here who can speak to this, I believe. But would you like to? I saw that you had some amendments to your legislation. So what Actually, is your?
I don't have amendments. I have a request to postpone discussion. I recently received, I recently paid attention to, you and Rob received this afternoon 3 new pieces of information coming from a subcommittee that has been looking at this piece of legislation. They would like to meet with me or us, depending upon your druthers, to go over some work that they've been doing with the Baltimore Metropolitan Council. This is one of the documents I sent you today. And I believe this is a group that Dr. Nash and other directors of planning and zoning have worked with over the years. They have proposed a number of recommendations that they offer to the Planning Commission's comments on the legislation. And I, quite frankly, have not had the time to go over that. I'd be happy to discuss any of it now, but I need more time, and I think this has been waiting in the wings long enough. It can wait for one more meeting, either a special session of the Rules Committee, or even defer it till the next monthly Rules Committee meeting.
I would be interested in hearing Dr. Nash's reaction, because what I gathered from, and I did a cursory preview of the document, their recommendations are contrary to what the Planning Commission recommended. No, you're shaking your head.
Was this the technical committee, Alderman Arnett?
Yes.
Okay. I was on this subcommittee. I participated in this subcommittee, and so I know their recommendations pretty well. I don't think anything they recommend would contradict what the Planning Commission recommended. If anything, if you compare our current guidelines to other jurisdictions in the area, we are meeting all of the best practices, with the possible exception of having a little bit more robust language about safety considerations in our traffic studies. But I'd be happy to go through their recommendations and ways we could strengthen their guidelines. But the Planning Commission basically sort of went around back to kind of keeping it the way it is now, where our guidelines are referenced in our code, but separate from the text of 22. And they thought it should stay that way, although we should change 22, that section of Title 22, so it matches the other sections of Title 22. Because I think your original intent was kind of irritated that not irritated, but that the problem with that section of 22 is that it looked much different than the other sections, and there was no discussion of metrics or, anything else that the other sections have. So I think we could still fix the ordinance so that section of 22 matches the other sections of 22, and then I could come back with the guidelines, or we could do it all at once. It doesn't matter to me. I committed to the Planning Commission that I would come back with the guidelines because those do need a little bit of updating in addition to the safety information. But yeah, so whatever makes sense to you, I'm happy to do it either way.
I see Alderman Savage has his hand up, but
I did see his hand. I did have another question for Dr. Nash. Do you think putting this off for a month would give you opportunity to look at it as well as get the Planning Commission's response?
I don't know if I can get their response in a month, but I'm happy to start working on that. It might be maybe two or 3 months, depending on their schedule, but I don't think that's will be a big delay.
Okay. Alderman Savage?
Well, thank you, Madam Chair. Yeah, Alderman Arnett, I'd support a motion to postpone action. I'm tempted to start to get into this again. I know we got into it a while back, I think in June, but so I'm tempted to do that again. But I think it might make more sense at this point to go back and review the subcommittee recommendations and to possibly, because I am one of the co-sponsors on this, I believe. So it gives us a chance to go back and possibly draft some additional amendments in response.
That probably makes more sense. I was wondering, could someone send me that email just so I make sure I'm looking at the same thing you're looking at?
Yes, I will do that.
Okay.
I don't know. I've got two computers going here at one time. I don't know if I might be able to.
I do have a question, though, Alderman Arnett.
Yes.
And perhaps the city attorney's office is a question, because the way it's organized right now in Legistar is a bit confusing. We have the ordinance as originally introduced with all the strikeouts and everything to the original code. And then you have two other pieces of legislation that are listed as amended by the sponsor, red line from the sponsor, and then the amended from the sponsor. But they refer to being amended on second reader, but I don't think this got to second reader yet. So I'm just, yes. I think if I'm confused by it, I think
yes,
others are probably going to be confused by it too.
Well, so my magic is working. I've got you confused. It's very confused because remember, this is one that was written and introduced, and then City Manager Teresa Sutherland got together with me and pointed out that this original piece of legislation was not written in parallel form to all of the other pieces of adequate public facility, not the same structure and so forth. So the way it worked out at council was we had to call the original up on second reader, and then I made a motion to substitute this version, the one that Teresa Sutherland helped me draft, for the original. And so it was a very confused process. I think that the version that Teresa and I worked on is much better in that it is in the same parallel construction. But then we have an additional complication in that the Office of Law under current direction has been looking at our code in general, but particularly titles 20, 21, and 22, and feel that they're way too cumbersome. A lot of things that are in the code should really be left to going into regulations rules and regulations.
Alderman, I guess that's good to know, but I think we need to figure out at this point what the best way is to have it show up in Legistar. And I think it would make sense to have, since it's been swapped out, maybe just have one piece of legislation, because the attachments that are listed as Arnett amendments, redlined, and then as amended on second reading, they don't include the original strikeouts of the original code. And so I think we might need to get that cleaned up in the.
Well, and my original question about the amendments were because it's labeled as Arnett amendments on second reader. So I think there is some confusion, as Alderman Savage has indicated. We've got the red line copy. We have the copy with the added new text that haven't been gone to council for second reader. So anyway, all that's being said, I agree. I'll entertain a motion to postpone action on 019 until next month's meeting. And hopefully that will give Dr. Nash an opportunity to go back and kind of review this, and also the sponsors, to make sure that any amendments that need to be included are thus so. So I'll entertain a motion.
I will move that we postpone consideration of 01919 until our next regularly scheduled rules committee. And in the interim, I will work on trying to clean up Legistar, although that's above my pay grade. I don't have control over Legistar, but so I'll make that postpone. By the way, Dr. Nash has been ahead of the game on all of this, and in the subcommittee, which was with the county and others, they have all said in public testimony that they want to do their traffic stuff the way we're doing ours. So we should take some credit that we're ahead of the game. Game on other jurisdictions. So kudos to Dr. Nash. So that's my motion.
Yeah, I'll second that. And I just wanted to, I guess, just state that Ashley, I was just Miss Leonard, just bringing this up for the law office's attention. I don't know if there's anything that could be done to maybe, I don't know, make it clearer in terms of what.
I'm sending out, I don't actually have access to Legistar, but I'm sending an email right now to the people who do, asking them to assist Alderman Arnett with maybe revising how those attachments are titled. And see what that, they don't give me permission to go in there and change things, but I will make them all aware of it.
Okay, thank you. And I think also, again, just showing in the one listed as amended on second reader, I think it needs to show the original strikeouts. But yes, I'll happily second that. But I also wanted to ask, do you think this may warrant, this is a question I guess more for the chair, warrant a special meeting or not? I kind of like to get moving on this, but also if you are planning, Alderman Arnett, to bring anybody from the subcommittee or planning commission, I don't know, but this might be something where we might need to dedicate a little more time, or from the Baltimore group that you mentioned. But we can perhaps talk about that in the future if we need to and set up a meeting. I see we may have lost the chair. Hopefully not.
I'm open to either process. There's a lot of moving parts to bring in the people from Baltimore and the people from the committee, and that really is up to the chair. We may want to have a meeting that is not part of Rules Committee, and then bring the results of that meeting to the Rules Committee. But we might get into some Open Meetings Act issues there as well. If the three of us on the committee are meeting with these outside people, are we now constituting a quorum and having a violation of the Open Meetings Act? I don't know.
Well, it's active legislation, so it may. Takia, Ms. Green, what?
Yeah. I was just going to say, if you guys are planning to have a special meeting to talk about this for rules. You may want to change your motion because you have it postponed until the next regularly scheduled. So you may want to change your motion to say that.
Well, that's what we're discussing right now. Rob was raising that issue.
So now I'm back, right?
We can hear you now, Sheila.
Yeah, you were here twice.
Okay. Am I on twice now?
Yes.
Still?
But we only hear you once. So that's
okay. But they only hear me once. Okay. All right. Thank you.
Well, now you're on twice.
Now we can see you twice.
There, now you're once.
Okay, now I'm on once?
Yep.
Yeah.
Okay.
So we may need to amend that motion in light of Ms. Green. I don't know if did you hear, Madam Chair, did you hear Ms. Green's comments?
I did not hear Ms. Green's comments.
So she was saying if we needed or decided to schedule a special meeting, then we might want to adjust the postponement to be postponed to the next, I guess, the next Rules of Government Committee meeting rather than the next regular meeting.
Okay. I don't know the difference between
what's the difference?
Regular meeting and the next. I would prefer that we reschedule this for the next Rules and City Government Committee meeting.
And that is my motion.
The February meeting. That would give Dr. Nash time without putting her under pressure, as well as Ross and those of us on the committee an opportunity to meet with this group from the Civic Association. So that would be my druthers also, and I think that's what the maker of the motion had indicated.
I'll second that again. But I'll second the reworded one for Ms. Green.
Chiquilla, Ms. Green, your hand was up. I'm sorry.
No, you guys covered it. When Alderman Arnett made the original motion, he said postpone it until the next regularly scheduled Rules Committee meeting, which would mean next month. Right. So that's why I'm saying you may want to have amended that to say the next meeting. And that way, you know, if you have it on whenever, if you schedule one for Thursday, we could put it on.
Well, I think his intent is the right one, to schedule it for the next regularly scheduled Rules Committee meeting.
Right.
I mean, we have waited for 18 months with this legislation?
At least.
So I don't think having to schedule another meeting in the interim is warranted, really. So, Alderman Savage, are you good with that?
Yeah, that's fine.
Okay. So the motion stands to reschedule, postpone action on 019-19 until our February meeting. Hearing no objections, all in favor, please say aye.
Aye.
Aye. All right, thank you very much. Next item on our agenda is 04820, animal control, canine leash laws. I see Alderwoman Tierney. Is this your legislation, Alderwoman?
It's actually Alderman Payone's legislation, but I co-sponsored it. I'm not prepared to speak on his behalf, but I can at least talk about why I co-sponsored it.
Okay, that would be helpful.
Okay. Well, first, I guess I should say that I am a dog lover. I'm still mourning the passing of my 15-year-old Maggie this past July, but I've also witnessed, specifically in Ward 1 public parks, the fright of children being confronted by an unleashed dog in public spaces, and I have been bitten myself by an unleashed dog downtown. And that certainly gave me a different perspective on the need for this legislation. Presently, these incidents have no recourse as calls to the county get an automated voicemail. Anne Arundel County Animal Control responds after the fact, and the dog is the one that suffers because they usually punish them with a muzzle or they're taken away. And I believe that a local police response would de-escalate the confrontation, and it perhaps would not reach that point where the dog would be punished. I understand the county presently has 2 animal control officers for the entire county. And with that field, not only with that field service area, but also sorry about that, but also the types of animals that they have, their hands are full. So I think as anything, we interpret legislation like this as sort of proactive. We were asking police to proactively police parks for dogs, and I don't believe that that's the intent, and we don't want to overburden our police department. But I just think that I don't believe it would be a big burden on the police to receive calls that warrant attention in a life safety issue, and that's meaning where someone actually feels threatened. And I believe that this is the intent of the legislation, that it's not proactive monitoring, but it establishes a logical framework to respond to a situation that could get worse in a matter of minutes. So that's my perspective. I'm not sure why Alderman Keown isn't here, but he has his respective Ward 1 reasons, I'm sure. Ward 2.
Thank you, Alderwoman Tierney. Alderman Arnett.
Thank you, Madam Chair. I spoke with Fred this afternoon about this ordinance, and there were 2 things. One, he indicated that he had not coordinated with the chief of police at this point to be sure that the chief was comfortable taking on this additional duty, which I think would be warranted. But he also indicated to me that there were several changes he wanted to make to the legislation, dropping out many pieces. Now, that's what he said to me, or at least how I interpreted what he said. But it feels to me like we kind of need to know what it is he wants to take out. And also, I do think it would be important that this is an additional duty for our police department, which is taking on a lot of other additional things right now, community policing, all of those sorts of things. And it would seem at a minimum that they ought to be on board with this duty. I think they have informally, if they've been called, they will come. I also think that a lot of this language is pretty much what has always been the case in that the county has been the lead responsibility. I think there's some clarifying language here about special kinds of situations with dogs that are in training or those sorts of things. But I do think it would be good. And I asked Fred if he was coming. He didn't indicate that he was to the meeting, but he did indicate that he knew it was on our agenda. So I don't know what to make of that.
Alderman, do you know what the real basis for this legislation is? I mean, is this incident driven? Is the county not responding? I'm not clear on why it's necessary.
Well, I can't answer why Fred took pen to paper. I can, again, only reiterate what I just said as far as the Ward 1 Parks perspective on it's just been an unfortunate situation. As I said, these are acute situations. You want a faster response, and in some of these cases, the county will come and pick up the dog and take it away because that's their job, where the local police would be able to ascertain the situation and it wouldn't reach that point. This happens because we don't have dog parks. We don't have legitimate dog parks except quiet waters and all. So, but I know he has worked on this legislation for over a year. I think he wrote it and then he pulled it and now he reintroduced it. So I'm very dismayed on why he isn't here to justify the initiation on his behalf.
Alderman Savage, can you shed any light on this?
No, I don't. I was just going to comment on it.
please.
So, yeah, I don't have any insight, but I do agree with Alderwoman Tierney in the sense that I think we do need more dog parks throughout the city. But this is I've received a lot of feedback on this legislation from constituents, and most of it was not positive. There was, I know it's not dealt with in this legislation, it's the attached associated resolution, but people were a bit surprised at the $250 fine. And I think Alderman Arnett or somebody may have told me that's the county's citation. But in any case, that seemed high. But I do think if the concern is that the county animal control is not doing a sufficient job, at least in the sense, in the perception of our constituents, then I think we should try to reach out to them. Because I think my primary concern, and I own 2 dogs, and my primary concern is that the police, maybe they are trained in this, but at least to my knowledge, they're not. I suspect they're not as well trained in animal control as the actual animal control officers are with the county. And so I just fear that this may lead to a point where they may be misreading the animal, and because the nicest dog can still get very defensive and bark, and that doesn't mean they're going to lash out. And I just could see this backfiring and having an officer shoot the dog or pepper spray or something or other, and just based on that inadequate training in this. And so I really think we should be having this stay with the county. If we do want to shift in this direction, then I think, again, we need to make sure our officers are sufficiently trained in this before we have them do this. But I also, I think we need to read closely the staff report, who does say that, by the city manager, who does say that the police department is fully tasked with the many current responsibilities. So there's certainly a lot of hesitation on their end in terms of, I didn't get a clear recommendation from them in favor of this. So I just think there's more homework that needs to get done from the sponsor before we take on this shift in responsibility.
Could I ask Mr. Manassa or City Attorney Lyles if they had anything to add to this discussion?
We have provided some advice to the maker, the proposer of this legislation, and there is an overlay with the county structurally that needs to be considered. Far be it for us to tell you what to do, but we didn't have any legal issues with the legislation, but there are structural implications because of the crossover between a department in the police department in Anne Arundel that has an animal control agency. We do not, and we'll have to buy municipal tickets that lend themselves to animal control, which we do not now have. So there are a lot of structural things that need to be worked out that are not necessarily legal and more administrative. And I think the city staff report provides that information. But for us, from a legal perspective, if you have a administrative body that cannot physically do the enforcement because of structural issues, then you have what's called a paper tiger law. It's got teeth, but you can't do anything because you don't have the wherewithal to do it. And it's very problematic to have laws in the books that are like that, because it calls into question all of the other enforcement that you're doing across the city.
Thank you, Mr. Lyles. Mr. Manassa?
Yes, Alderwoman Finlay. So I think I haven't read the legislation personally, but from the discussion I've heard, I don't think we would have any real impact, or it wouldn't necessarily impact our operation. I'm not sure how we would be involved with it. So it seems a little outside planning and zoning scope from what I'm hearing.
Mm-hmm. Okay. Alderwoman Tierney and then Alderman Arnett.
Yeah, I just want to add, if I understand this, and correct me, Michael, if I don't, is that animal control will still be, and the provisions thereof will still be under Anne Arundel County. The question is, oh good, he's nodding his head. The question is enforcement. But I think we're losing sight of, again, I wish Fred was here, is the genesis of this legislation is to prohibit dogs off leash. And somewhere that has to be stated. And I don't want to lose that objective, and get sort of, off with the enforcement part of it. So I think it is serious legislation in which we do have to prohibit unrestrained dogs. And then this issue of enforcement has to be discussed with the police department. And that should be.
Well, maybe I'm not clear. Do we not have leash laws in the state of Maryland already?
Yes.
So simply what we're talking about is how we enforce those leash laws in the city. Am I clear? Is that what we're looking at here? I see Ross shaking his head. Mr. Lyles is not.
Well,
Alderman Arnett.
So, yes, there are already leash laws. We've already had several incidences. Mr. Ledoux is here. He can talk to you about incidences that we've had here in Ward 8. But the main embellishment here, there are some definitions which I assume would be superseded by county definitions anyway, since we are part of the county. The main thing here is adding a responsibility to the police department. And when Alderman Payon told me this afternoon that hadn't been coordinated with the current chief, it had been coordinated with chiefs in the past, either Pristoop or Baker, he couldn't remember which. But since it hasn't been coordinated with our current chief, and I would assume that would also need to be a discussion through the city manager, Gerald. It really does feel to me like at best we should ask for a postponement until Alderman Payon can join us. I have to say I've been disinclined towards this legislation. I think it, as city attorney said, begs more problems than it solves. But I'm certainly willing to give Alderman Payon his day to come and explain it to us. I just think he needs to come and do that. But I also do think that we better be coordinating with the chief of police to make sure he feels that he has the resources to fulfill being, as it says here, the police, in addition to any other agency, the police department of the city of Annapolis shall have the authority to enforce all animal control provisions, which I assume are those provisions that are part of the county code.
I think I would be more comfortable if, you're right, Alderman Payon were here, but I also think that there should be a representative, not only from the police department, our police department, but from the county animal control department. You know, I think everybody needs to be in the room so we can be clear on what the intent is and how it impacts both agencies. So I would entertain a motion to postpone action on 04820 and invite Alderman Payon as well as Chief Jackson and a representative from Animal Control to join us at our next meeting.
Just let him know that I gave it the college try.
Will do.
Thank you.
So I make that motion.
I'll second that, but I want to ask just for follow-up purpose, who will be inviting the people you mentioned?
I would ask Ms. Green to invite someone, whomever they'd like to send to us from animal control at the county level. I don't happen to know. I did know a gentleman who was one of the two animal control people. I'm not sure he's still there, but surely someone in, and I don't even know what department that falls under at the county level.
The police department.
What is it?
The police department, ma'am.
Oh, it's under the police department. Animal control is under the police department?
They have
Okay.
a section of
And I would ask that we reach out to Captain Awad and ask her to send a representative from that division within her department. Alderman Savage?
Yeah, thank you. Just one other thing. Looking in the code, I don't see anything in our code about leashes, but it does reference, the law office would know better than I, but it references Maryland criminal law, section 10-619, which deals with dangerous dogs. But in any case, I guess the animal control will probably have some good understanding of these various laws as well. But I guess what I'm getting at is I'd like to know in the future just how these different laws are coming together here.
Well, again, and that's why I think having everybody in the room at the same time we'd be able to ask those questions.
Okay.
I see Ms. Green's hand up. Ms. Green, you're muted and we only see the top of your head.
Sorry, I'm trying. Chris Ledoux is on and he wants to speak to this legislation.
He would like to speak to this legislation?
Yes, ma'am.
Okay, then I think we should let him in since he's been waiting to share his comments. I see him on screen. Mr. Ledoux, you're muted.
Thank you. Thank you, Chairman. Happy New Year, everybody. Thank you. I'll be quick because I know you were about to make the motion to continue. So I submitted written testimony on the legislation, generally supportive. I just give you some of my impressions of it. Under the current city code right now, we basically incorporate the county rules. And by large measure, this ordinance basically is a mirror image of the rules of the county. But there's several important things it does. Right now, under our current code, the chief animal enforcement officer is Dr. Nash. For some reason that nobody can figure out, the planning and zoning director is the person responsible in the city for animal control. And with all due respect to John Manessa, who's very busy, I haven't seen him running around, chasing dogs. He's got plenty of other stuff to do. That's number one. The second thing to remember, as I recall in the ordinance, it's not only police enforcement, but there's also a provision here for an affidavit enforcement. In other words, if you were to see me with my dog and my dog was offline, you could take a snapshot with your cell phone and then swear an affidavit to the police officer that on this date at this time you saw me with my dog off leash. And that's also an enforcement vehicle that's been written into the ordinance. Alderman Savage, with to your question about leashes, you are correct, but that's because it's embedded in the definition of at large. At large means a dog off a control device, off a leash, etc. So that's how that's incorporated. And I'm delighted for the support of more dog parks. I echo that. And Alderman Savage, maybe we could even couple that with dog parks with trees in the parks. Thank you for your time. Sorry to delay your continuance.
Thank you, Mr. Ledoux.
Fred has sent me a text saying that he can join us, but I don't see him joining us.
Saying he can or he is planning to join?
Well, I said, can you join us? We're talking about it. And he said, yep.
Well, we do have a
but then he says, Ellie is the best bet. Sheila was fairly strong about not considering anything that could lead in a way to profiling. There's Fred. He can speak for himself.
Okay.
Alderman Payon, welcome.
Thank you.
We're talking about your legislation, your animal control canine leash laws legislation.
Yes.
So I guess the first question is, what was the problem that you are addressing with this legislation?
The failure of the county to be, the inability of the county to enforce the leash laws in particular, but the animal control laws in general. There's a distance involved. the specific problem that I've had has centered around the recreation fields behind Germantown Elementary. There are numerous practices and games that go on there, usually for younger children. And people bring their dogs to the games, and they either let them off and run and let them run, or they get off the leash and run. We've, excuse me, had a number of dog bites. In terms of the neighborhood, there are a number of people in the neighborhood that think that it's okay to let their dogs run there. And while I'm not unsympathetic with letting dogs run, I'm a dog person. I've got a dog. I've had dogs, I don't know, 20, 25 years. And however, you know, you can't do that. And people are doing it left and right. It's not exactly the crime of the century. I'm well aware of that, but it has caused problems. And some dog owners, and I want to emphasize only some, have acted very irresponsibly. And actually, the two biggest offenders are very well known to those of us on the council. But it's a problem. And the problem is the response time. You know, it can't really be enforced the way it is right now. That's the problem.
Okay. Are there signs posted in those recreation areas? You know, no dogs unleashed or whatever?
Yes, there are. It's also a problem in Poplar Park, which of course adjoins the fields I just mentioned. Poplar Park goes along the old railway bed from Parole all the way through Germantown. As a matter of fact, on the very front of the Germantown property, it's parallel with Poplar Avenue. And I think ultimately it turns into the driveway into the Lowe's Hotel, or the Graduate Hotel. People use that to walk downtown. It's a very well-used area. It's a very nice area, but there are problems. You know, we've had kids bitten. We've had, probably more than anything, we've had other dogs being injured, having to go to the vet, that sort of thing. And by the time the county comes down here, these dogs and their owners are long gone. There'll be times when the police will have certainly bigger priority calls than that, and you know, may not do any better than the county would have done, but I think by and large they will. I don't know what else to say about it. I've got a call into the chief right now. I spoke with Branford, Deputy Chief Branford, and he wanted to talk to the chief because I know there are concerns about adding this to the duties of what at times at least is an overburdened police department. And I'm aware of that. And I think it was Chief Baker when we first started talking about this, putting something in, and Baker was fine with it. He understood, I think, that it was, I think he had some experience because the police end up getting called anyway for these things, and they're not going to not respond if they get a call. You know, if they say, hey, there's a dog running around biting people, the police will come out. And I think no matter what we do, now they may not be able to issue a citation. I mean, they may not be able to do much about it, is the bottom line. But if, you know, if the chief says, look, we can't handle this, you know, I got to think about withdrawing the legislation. I'm not looking to overburden the police department. I don't, as I said in the past, when we first considered filing this legislation, it was fine with the police department. different administration, they may feel differently, and I think we all need to be sensitive to that.
Thank you, Alderman. Alderman Savage.
Thank you, Madam Chair. Yeah, Alderman Payon, I'm not sure how much of our comments you heard before you signed on.
None.
Okay, so my two concerns are one, the staff report, which does say that the police are fully tasked with their current responsibilities, and they're in favor of animal control from the county continuing to deal with that. But my second concern is just whether or not our officers have training in how to control animals, because I could see a situation, unfortunate situation arising where they may take action against a dog because they can't read them or understand the animals and don't have the equipment to deal with that. So I think, I mean, maybe if do you have information on that, like in terms of our capacity for the police department in that regard, in terms of resources and training, and because I think that would need to get addressed before this would.
Yes, I think they all receive training in the police academy, but they don't receive the type of detailed training that an animal control officer hopefully gets from the county. I mean, I really don't know anything about that, but I do know a little bit about that. At least in my days in the state's attorney's office, they used to receive training. Are they experts in the handling of all situations? I'm guessing not, but they do have some minimum amount of training. Of course, this frequently evolves into the owners versus the victims or their families, and they certainly have training in handling that type of situation. I mean, it's a real problem at times. I mean, we've had dogs actually bite kids who were in the middle of a lacrosse game. I mean, it's bad enough when the defense is chasing you down the field. Now you got Rover joining the defenseman. I mean, and it's not a problem most of the time, but it is a problem in the spring, in the fall, particularly when crowds gather there. Obviously, there's not been a huge problem this time, although I did get complaints that prompted me to file this again. I mean, I don't know totally what the answer is. This is, I think the best we can do, at least at the moment. I'm not pretending that this is absolutely perfect. I think Ellie could probably better speak than I, the problems they have downtown. When we get the crowds, and I'm amazed because every place I've ever heard of, you simply can't. It's understood by everyone that, like it or not, you got to leash your dog, and some people think that they really don't have to do that. And the biggest offenders are well-known folks that I thought had better. You'd think have better judgment than this, but not much I can say.
Alderman, we were at the point of getting ready to postpone action on this legislation so that we could bring in the police chief as well as a representative from the county animal control to see if we could work out what the issues are. It sounds to me like there may be some other options for dealing with this if we got everybody at the same time around the same table.
You know what? Not only do I not have any objection to your doing that, I think it's an excellent idea. I was considering asking to have it pulled from Monday's agenda anyway, and I think this will help get it pulled, legislation pulled that may not be ready to have us deal with it. It's not for want of trying, but I could probably talk to the folks at Animal Control. As a matter of fact, actually, the Animal Control is a division of the police department countywide, and there is I believe, a lieutenant who is in charge of animal control. I think it's a lieutenant who may not be on the best of terms with the chief who put him there, but nevertheless, it's a higher up in the police department that does run it. So, you know, there's precedent to having the police involved. I mean, they're involved right now.
Well, and from personal experience, I had to call animal control a few years ago for what I thought was rabid raccoon. And the officer that came out was not a uniformed officer. He was a civilian working in that capacity. So, but anyway, we can find out when we ask them to come in, share with us.
I think they are civilians, but I also think that the county police do have the authority to enforce animal control laws. I mean, they've had rabid dogs before, and you may have read about it, that a police officer regrettably took his gun out and shot and killed the dog. And that's authority. I guess we would have authority to do that here because there's an imminent danger of humans either being made sick or worse than that, being mauled by a dog. And I think the police would have the authority to do that, to do something about it. But
Fred, your wish is granted. It's not on the agenda sent out by Jacqueline.
Okay.
Okay.
I thought.
That's
okay. No, I think you're right.
Okay. Alderwoman Tierney, and then I'll entertain a motion to postpone.
Yeah, I wanted to say something before the motion is entertained, Madam Chair. A little background, Director Trader brought similar legislation or concern to me over a year ago as far as going as far as banning dogs from playgrounds, and we can't do that. We have shared parks and playgrounds, and that's the prevalent problem in Ward 1 is that our parks are shared with playgrounds, so dogs off leash are a concern. I would make a suggestion if my colleague Alderman Payon agrees that it would be nice to have Director Trader's perspective at the next meeting. At your next meeting, if that's
already dogs are not allowed on school property during immediately before and immediately after school is in session. That wouldn't take care of much of, doesn't take care of much of my problem, but there's a little bit of help there that we're getting that isn't necessarily addressed in my legislation.
Alderman Arnett, I think there was an issue. I think dogs were not allowed on Reverend J.J. Turner Park on 3rd Street. I remember there was a discussion about that a year or two ago about. So I think it varies.
I think there are some legal questions about it. So it would be good to get Director Trader for our next meeting. But Fred, we don't have enough legislation to take care of your problems.
I'm not going to comment.
There has been a motion in a second to postpone to the next Rules Committee where we can invite appropriate people to speak to this. It is not on the City Council agenda, the draft agenda that was sent to us.
So Ms. Green, would you add Director Trader to that list of invitees for the next meeting? Okay, further discussion? Hearing none, all in favor of the motion to postpone action on 048, please say aye.
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 All right, and our last item.
Thank you, Madam Chair.
Thank you for joining us, Alderman.
Thanks, Fred.
You're quite welcome.
My other computer has gone to sleep because we took too long.
It's all wrong.
No problem at all. Okay, next item is R6120, short-term rental licenses, moratorium. And I know we have a couple of speakers waiting to present testimony to us. Is there anyone who'd like to make comments from the committee before we begin? inviting our guest in, or Alderwoman Tierney. Alderman Savage.
Yeah, thank you, Madam Chair. Just wanted to comment on this. I did sign on to this as a co-sponsor because I do think it's a good idea for the reasons that Alderwoman Tierney went through in the legislation. And I think even looking at some of the information from our own staff reports and things that is helpful to see, but it actually, I think, supports this legislation in the sense that they said there were, bringing up now, approximately 100 total short-term rental license applications in the past 12 months. So that's how many they've received, including both new and renewing licenses. And so of these 180 were located in the C1 and C1A zoning districts, which are the only districts that would be impacted by the moratorium. And so they say this, let's see, a majority of these 80 licenses were not owner occupied. And so if you remember from our discussions during the last, the legislation that we did on this short-term rentals, those non-owner occupied are really the ones that are more impactful to the community in the sense that they displace and prevent long-term residents from living there and really impacting the feel of the neighborhood itself. And so I'm really I was shocked to see the staff report. I mean, these numbers are high and it's all happening in these two districts. And that's, again, why we were trying to address this issue back when we did. And so I think that again, supports the need to go ahead and pass this moratorium until we do get a better understanding of what's out there. Because again, I don't think it's good to be impacting these neighborhoods, and also looking at the C1 and C1A zone, as the Alderwoman Tierney is probably going to get into, but as she states in the whereas clauses, it clearly establishes the intent of these zoning districts, and it really does seem that we should be taking steps to protect them until we really get a handle of short-term rentals that are in the city. But it doesn't prevent anybody from submitting a renewal, I believe. Correct me if I'm wrong, Alderwoman. So anyway, that's why I'm still supporting this. But you're muted.
Thank you, Alderwoman Tierney.
Thank you. I just want to just spend a few minutes, again, redefining what this is, and before we continue and ask questions. As my colleague Alderman Savage said, it's been about a year since we amended the short-term rental, the Title 17. And a current city contractor we hired is working to identify how many we have, because during the testimony there were so many inconsistencies on numbers, et cetera. So we have moved forward and hired a contractor to identify them. And as my colleague said, the initial findings are troubling, that in the last year, the majority of these licenses have been concentrated in the C1 and C1A zone. So why is that important? Just bear with me as I reiterate the importance of this. Let's see. Can you all see that?
Are you sharing your screen? Is that
yeah, can you see that? Okay. Now I have to move you guys out of the way, but just so there's no cause for panic here, C1 and C1A, as you can see, are the light purple and the little medium shade of purple. The dark purple is commercial. It does not include commercial areas. there's a C1 and C1A, which is also overlaid by the historic district. It is prime real estate. It is very preferable for this for platform industries because of its proximity to the Naval Academy. As you can see, it's 3 blocks away. So logically, with the advent of platform, businesses, they migrate to C1 and C1A. And so another reason why that is important is the definition of C1 and C1A and how they came to be. And I'm going to share something else here, if I may. Bear with me. Share screen. Can you see that?
Not yet.
Oh, okay. Maybe not. Okay. So extracting from the code, the C1A is a special conservation residential district, which was defined at risk. And you asked at risk at what? What was at risk? And at the time of the Ward 1 sector study 20 plus years ago, it was impacted by non-conforming uses and other things too, as well as unmaintained lots and commercialization. There were some cases where an insurance company wanted to just use a residential storefront, and that created a whole flurry of things. And so the code. The process worked. This was identified as a problem 20 years ago. It went from the Ward 1 sector study to the comp plan, and then now, as you can see, implemented in the code, identifying them as at-risk conservation residential districts, and then C1A as well as the same focus. And those particularly because of the proximity to St. John's College, et cetera, what other uses to prevent multi-family use and all that kind of stuff. But so what's happened though, the problem is that what is a non-occupied short-term rental? It is a platform business. It is a house that a business is in, and I know that during the testimony I was recused from. A lot of my constituents got up there and they voiced concerns that were, concerns, but from my viewpoint, even though I was recused, it was, sort of like the headaches and all that. It's not so much what they are, it's what we are losing. And we're losing neighborhoods. This was very evident during the pandemic. Extremely evident during the pandemic. Unfortunately, their business was suffering and those houses remain empty. And what does an empty house contribute to our local businesses? If we had more residents, they could have supported the local restaurants. They could have supported downtown. And so what this is just in reaction to these issues, I'm proposing this moratorium specifically for those conservation districts and only for non-owner properties due to the issue that I just spoke about. And it is just a suspension and to a date certain. Well, what is that date certain? The date certain is allowing time for my residents and your residents and every resident to have their input into the comprehensive plan, and then allowing time after that. So it's 6 months after the approval of the comprehensive plan. And meanwhile, concurrent with that, I will be looking at some options to address these in the future. One of the biggest questions is, what are they? And I know planning and zoning still considers them dwellings when in fact, you could argue that they are a business. I know on city waters, the harbor master has called, platform Airbnb a business. So that has to be worked out. So, and again, all property owners with current short-term rental licenses may continue to operate. All owner-occupied properties are exempt. This is strictly for non-owner occupied short-term rentals, which otherwise known as investment properties. So that I just wanted to reiterate that definition. And I also want to thank my colleagues. I know this is the last thing you wanted to see was any legislation with the word short-term rental in it. But as you can see, the last year has proved that this needs to be done. This timeout, if you will. So thank you for my time.
Thank you.
Here.
Yes, thank you. Any other? Before I call in our speakers that are who are waiting, I do have one question, I guess, from Mr. Manasseh. Do we have all the numbers on short-term rentals for the last year? I mean, what's outlined in the staff report are simply in the C1 and C1A districts. But do we have the numbers for all of the districts in the city?
Well, I wouldn't. Okay, go ahead, Sally.
Sorry, go ahead. I wasn't sure if you were there. Go ahead.
Well, Sally was able to pull some numbers earlier today related to the C1 and C1A, but I don't think we've looked at the city elsewhere in the zoning categories outside those two. Have you, Sally?
I have seen, I'm trying to remember where I saw that. Oh, we can get that data. I don't think I have it available right now. I just pulled the data for C1 and C1A zoning. And then I cross-referenced short-term rentals with city zoning, but it's easy to pull that data. Is there a specific question you had about that?
Well, we're just focusing on these two zoning districts, and I'd just like to know the impact on the other districts also.
Well, there wouldn't be an impact from this legislation on other districts.
Right.
I would say that besides C1 and C1A, the zoning district that has the most short-term rentals is R2 and C. But I could give you the exact numbers if you like. I know Alderman Arnett sent me several questions that some of them I know, but some of them I would need more time to research. So I'm happy to do that.
Okay, I'd appreciate that.
I think just
go ahead, Mr. Vanessa.
Just like in a real quick blush, what we saw was roughly 136 short-term rental licenses citywide. And if there were 92 of them in C1 and C1A, that only leaves a little over 40 elsewhere in the city. So it's not a great big number in any one specific area, I would think, other than maybe Ward 8 has probably a higher number than the rest by a small margin, but I'm not really sure.
Okay. Well, if we're being presented with these numbers, I just like to have something with which to compare them. So thank you. Alderman Arnett.
So I have an urgent request from one of the people who would like to speak that they've got another meeting to go to. I'll come back, but I'd like to see the data pre and post legislation. I mean, how do we know what the impact of the legislation was unless we know what the picture looks like before the legislation and after? But I have many other points, but I think we've had our guests waiting for a long time. It might be good to let them speak and then let them go.
I agree. Julian, are there two people waiting to speak? You can let them in. Okay. Now, Mr. Bariano, welcome.
Hi, how are you all? Can you hear me all right?
We can hear you.
Well,
Can't see you, but we can hear you.
Well, thank you. I'm in a jacket and tie, and I'm before the City Council. And Happy New Year to all of you. And thank you for the opportunity on behalf of my client, Expedia, to say a few words. Very disappointed by this legislation. A year ago, approximately, an enormous amount of time and effort was spent in hashing this out, in having extensive conversations on this legislation. Very respectfully, I'm not trying to be rude or disrespectful. I heard what Alderman Savage said, and then the sponsor, Alderwoman Tierney, said that there is a lot of rentals, short-term rentals, in this particular area. So what? What's the point? I don't understand the point. Is there an increase in crime in that area, or violence, or garbage, or what? Again, unfortunately, we're getting back to this non-owner occupied, so that like the people that are in this short-term rental, they're questionable people. They're bad people. They're not civilized. They don't know how to live in an orderly, proper fashion. There's no difference in reality with short-term rentals and long-term rentals. I own 2 townhouses on Pinckney Street, which I believe Alderwoman is in your ward. I rent them out on a yearly basis. The renters are they're not owner occupied. They are people that are renting it out for a year. There's no problem with that. Of course, I have licenses and I'm inspected and all that kind of stuff. But what is the real difference between someone signing a 12-month lease, which they do, and possibly renewing it, and then someone coming in for a weekend or what have you? As the older woman, as you indicated, the area in question is absolutely prime visitor and tourist areas. That is where people, all of Annapolis is spectacular and wonderful. People want to come see the Naval Academy. They want to see the dock. They want to see the State House, the oldest in continuous use in the United States, all sorts of stuff. So that's why they congregate there. But we're really rehashing something that was very painfully and arduously voted on and decided by the voters. I believe when it was adopted, there was a motion made by one of the aldermen to instead have a study rather than pass what was passed a year ago, and that was defeated. But what disturbs me in my conclusion is that what's the relevancy that they're not owner-occupied? What is the point trying to be made? That these are bad people? That they're suspect people? That they don't live properly? And then secondly, so there is a concentration there. What is the point? I can't understand the point unless one is trying to accept that you don't want people, that and that look like you and that have been there for a long period of time. When my people come in and rent out my place for a year at a time, they're not locals. They haven't been there before. They're new in the neighborhood. So what? We really have to look at a broader humanitarian standpoint, and particularly in our society today, things are so sensitive, and they should be sensitive. And I really think that this legislation doesn't look good. It appears discriminatory, which I believe it is, for the rest of the parts of the city. And I think in conclusion, to concentrate on non-occupied owners, people coming in and being there and stopping them for a period of time. There's been no clarification of how long this moratorium would go on. Is it going to be a couple of years or what? This is wrong. This is bad. And I got to believe this is going to be challenged if God forbid it were to pass. And it's not going to look good for Annapolis. And Annapolis has far more important things in this COVID-19 to pay attention to and to deal with in terms of the economic recovery. This certainly, in conclusion, is not an economic recovery piece of legislation. Thank you very much. I'll be happy to answer any questions.
Thank you, Mr. Veriano. Any questions for him? Seeing none, we appreciate your testimony, Mr.
Thank you for the opportunity, and have a good evening, everyone. I'll listen to the discussion. Thank you.
Thank you. And Julian, I think there is one other speaker waiting. Mr. Ledoux.
Thank you, Madam Chairwoman and council members. Happy New Year again. I didn't know a tie was required, but I'll dress appropriately next time. Listen,
you can tell us that anyway, though. We can't see you.
Yeah, I submitted written testimony to the City Council, and I'm not going to repeat that. I said there were some issues I wanted to raise with the Rules Committee, specifically to what the Rules Committee's kind of mission is. And what I wanted you to consider is whether or not a moratorium is an appropriate public policy tool under these circumstances. And I do mean this. I do understand the arguments that Alderman Savage and Alderwoman Tierney are making, and that, my neighbors and residents downtown, I'm not unsympathetic to those. But this resolution is not relitigating those broader issues that we all acknowledge we still may not have landed at the right balance. And we may still, and I hope eventually we will get to some kind of consensus position that will work, where not everybody is happy, but not everybody is unhappy. But that's not what this resolution does. What this resolution proposes is a moratorium. And the purpose that is outlined there is so that there can be some kind of inventory taken. And then, in addition to the inventory, implicit in that is that we want to maintain the status quo for the comp plan and comp plan plus 6 months. So it's not about the broader issues. It's about whether or not a moratorium is appropriate for purposes of doing an inventory and waiting for the comp plan. And I suggest it isn't. In fact, I think it works against that purpose. First of all, licenses are short-term themselves. They're only valid for 1 year. They're not permanent. And there's no risk when you do the comp plan and whatever follows the comp plan. If you change the rules for short-term rentals, there's nothing permanent. Licenses can simply lapse, not be renewed, or even revoked. This is not a situation where in the past the City Council imposed moratoriums on like annexations or planned developments until further rules were developed. You can't unbuild a hotel, you can't unbuild a shopping center, and you can't kick out an annex section of Forest Drive after the fact. But rental licenses of any category are not permanent. Second, I would point out that the Maryland Department of Planning, and Dr. Nash can confirm this, but best I can tell from the schedule, the City Council doesn't have to adopt its comp plan until 2025. Not only because of the changes in state law, the state's given municipalities more time, but even now the census is delayed. And with all due respect, and I mean this in a good way, not as a criticism, you're not breaking any speed records, right? I mean, you're still working on sector studies and everything. And that's a credit to your process because you're overly transparent, you're very inclusive in public engagement. But for Pete's sakes, how long would this moratorium go on for, and for what purpose? Now, in addition to that, it's not clear to me how a moratorium is going to help with your inventory taking. According to the Department of Planning and Zoning, they'll be able to give you the inventory as soon as they run the correct data, right? There's some work to do, et cetera, but it shouldn't take more than a couple weeks. I assume also our new contractor has that capability as well. So what is this inventory taking that suddenly we need to have a moratorium in this big undefined length of time to do? What's involved? Who's doing what? What information are we collecting? And then if you're not allowing people to get licenses, a certain category of people to get licenses, how are you going to get information about them? How are you going to be able to project the amount of new licenses that may come online when the moratorium is lifted? How will you ever be able to know that there's some equilibrium point at which, there seems to be a cap at which the licenses level off if you curtail it? Now that said, I will put my legal hat on because I am a lawyer, but I'm not going to get overly lawyerly here. You have a very capable city attorney. I have a lot of respect for him, and Ashley is on the call as well. they're very capable attorneys. I will tell you here that whenever legislation treats similarly situated people differently, it invokes questions of unequal protection under the Maryland Declaration of Rights. Now, there's different tests the courts apply, and I'm not going to get into that and argue. I think the Office of Law and I would agree that at the minimum, the court would apply what's called the rational relationship test. However, the Maryland Court of Appeals has held in cases where legislation affects economic activity, like renting, as well as cases that involve geographic classifications, like zoning districts, the court applies a heightened scrutiny test. Now, regardless, maybe Michael and I would agree or disagree as to what test, but in any scenario, the resolution as drafted wouldn't pass either test. And let me explain to you why. First of all, you have to explain why you're able to inventory every other type of short-term rental license. In other words, owner-occupied without a moratorium. You have to explain why you can inventory non-owner occupied everywhere else in the city without a moratorium. You also have to explain, even within the historic district, Alderwoman Turney held up the zoning map, there's a whole number of zoning districts downtown. But yet we don't need a moratorium in the C2, even though the C2 might be right across the street from a non-owner occupied in the C1A. We don't need one in the C2A, even though that might be right across the street from one in the C1A. So you have to explain, like, what is special about the C1 and the C1A that makes the Department of the Planning and Zoning incapable of conducting an inventory on those properties for this one little subset of short-term rental license when they don't need a moratorium for the owner-occupieds in those districts, and they don't need it for any other license in any other districts, including the R2NC. There's no rational explanation for that. Now, I understand, as Alderwoman Turney points out, that, well, these two districts, the purpose is talk in terms of at-risk districts. Now, I plan to talk about this more at the Human Relations Committee, but as I pointed out in my written testimony to the council, this language about at-risk neighborhoods has a very suspect history, as has been examined by civil rights advocates and fair housing advocates used elsewhere in this country. And I am very troubled, without necessarily finishing my complete research into its genesis. I think it goes a little further back beyond 20 years. But I really question this sort of at-risk classification. The second thing I'd like to talk about is, as I understand the argument about dark houses. Okay, that's fair. But, none of this legislation or resolutions or ordinances address dark houses. We don't talk about my neighbor who's been on an academic sabbatical for 18 months. Her house is dark. It doesn't talk about my other neighbor who is elderly and now lives in a one-story or one-level townhouse and has, doesn't want to sell her house. It's been dark for years. It doesn't talk about some nonprofits in town that buy up these historic houses. No one lives there, they're dark. It doesn't talk about people that are snowbirds. Their houses are dark. So there might be a lot of reasons why there are dark houses. And again, none of this seems to be only pinpointing that, one specific contribution to that overall maybe complaint. The second thing I would like to tell you, and this does really concern me. And that's this argument that non-owner occupied short-term rentals are businesses. Let me enlighten folks here a little bit, and I'm happy to get with the Office of Law and share with them the case law. That issue was decided about 12 years ago by the highest court of the state of Maryland, the Court of Appeals, in a case involving short-term rentals in a residential homeowners association community. And the court talked about how other states may have concluded that these were businesses. But it's the law in this state, definitively the law in this state, that short-term rentals are residential uses. So, you know, I do get a little bothered when people talk about them being businesses or commercial uses. I understand in reality why people make those analogies, but it's simply not the law in the state of Maryland. So again, when you look at whether or not the moratorium has any connection with conducting this survey or this inventory, which I don't even know what the scope of that is. You know, at the federal level in my work, when we do surveys and analysis, we don't impose moratoriums. We do snapshots, right? We decide, okay, we're going to look at the data as of year end, 2019, or we're going to look at it as of first quarter. We don't impose moratoriums to do that. So why here? And so again, what I would like to encourage this committee to do is to think about really whether or not a moratorium, which can be an appropriate tool, it's really, when you think about it, it's a very serious tool, because basically what you're doing, whether it's this or something else, is you're basically prohibiting someone from doing something that is legally permissible. And so you're saying, okay, a timeout for some undefined period here, for what purpose? And then what you're doing is you're not treating me the same way as a non-owner occupied in the R2NC, or a non-owner occupied right across the street in the C2, right downtown from me, or even my neighbor who's an owner-occupied renter. And to tell you the truth, last weekend when my guest moved in and his guest moved in, it's the same impacts, right? It's the new families came to town, they drove their cars, they parked, they went downtown, went to restaurants, whatever they did. It's the same thing, but somehow, because the ownership status of our properties, this somehow affects the moratorium and Sally or the contractor plan to collect the data for. So I just don't think it adds up. I think this is really, with all due respect, I think this is getting wrapped up in the broader debate and not the moratorium. And what the purpose on paper, at least, is, which is to conduct a survey and to keep the status quo to the comp plan. So I encourage the committee to help me and the public understand why you're treating us differently in this one little couple sections, geographic sections of the city, but you seem to be able to do the inventory elsewhere. And if the question is, well, it's just the number, then we've got issues to determine why suddenly 90 is too much and 40 in the R2NC is enough. And at what point do we get so many in the R2NC that we need a moratorium there? So I really encourage you to try to help me and the public understand why you're asking us to suddenly not be able to, do this activity while something's going on, which is not exactly been explained to us. Thank you for that. I'm sorry. And Alderman Tierney, I'll shut up. I see you raising your hand, so I'm sorry. I'm very passionate about this, and thank you very much for listening.
Thank you, Mr. Ledoux. I think I'd like to call, before I called on Alderwoman Tierney, Attorney Attorney Leonard is on, as well as City Attorney Lyles. Do you, either of you, have a response to the questions about the legality and the fairness of this legislation? Ms. Leonard, I know you had written, I think you had written a statement to us about that.
I did. I don't have any response at this time, only because I don't want to give legal advice publicly. I'm happy to do so in a follow-up opinion or a closed session. If we really want to get into the merits of a legal analysis, I think a closed session would be a good idea. I'm happy to look into the points that Mr. Ledoux raised. It hasn't necessarily changed my opinion as of yet, but I defer to the city attorney if he has any other thoughts.
Mr. Lyles?
I have no other thoughts.
Okay, thank you. Alderwoman Tierney and then Alderman Arnett.
Yeah, let me just simplify this. I think everything we've discussed is really a reason that we should have this moratorium. There are a lot of unknowns. We don't know what to call these things. What were some of the other things Marty said? It wasn't Mr. Ledoux, by the way. It's Marty Edsel, who owns a bed and breakfast in Ward 1. So what the reason for this moratorium is to answer those questions, and this is the biggest one. And it's not about me. It's not about us. It's about the city's definition of the code and how much they want to protect it. Because this is the future of C1 and C1A. That's not my decision. Boy, oh boy, that code says that we need to protect it. And the difference with an unoccupied dwelling and an occupied dwelling in a protected residential district is pretty severe. And I think there's misunderstanding out there. This is for non-occupied investment properties. They're typically bought by a second, they're bought as a second home, and they are empty during the week. And the reason why we need this moratorium is that the trajectory since we passed legislation a year ago is unsustainable for C1 and C1A. The numbers are prove that these licenses are still being approved, and we're basically going to lose C1 and C1A as residential districts. If that's okay with everybody, fine with me. That's why we have this public discussion. But the reason for this moratorium is a pause button. I'm not suggesting Airbnbs are not going away. We know that. But I want to protect a residential district. And you ask from what? Well, ask the people that authored that code. I mean, ask what this is going to be the second time we did this, and the first time was ugly, and we know what happened. We lost our entire African American community, and now we're doing it again for different reasons, but the principle is still the same. So I'm not going to protect our code. I'm looking at help from planning and zoning to do so, but we can't not do anything because the trajectory is not in our favor. And I'm asking you just for this temporary pause until all these questions can be answered during the pause, get into the comprehensive plan, and we know the future of these specific zoned areas.
Thank you. Alderman Arnett, and then Alderman Savage.
Thank you, Madam Chair. Well, I have lots to say and not much time. We have a Board of Appeals meeting tonight at 7, and I have to get to that. But I'll say 4 major things. One, I think this legislation is inopportune. I think it's not ripe. I think it's improperly constructed. And bottom line, I think it's not honest. And I think that there's an awful lot of things that are going on underneath this. I think it's not opportune because right now we are going through COVID, and right now is the short-term rentals are the way that people can come to the city of Annapolis and stay, not in a hotel, and can support our other businesses downtown. So it's absolutely the wrong time to be getting into this, no matter what the other reasons are. I think it's not ripe for many reasons, not the least of which is we just started collecting this data. As you pointed out, Madam Chair, we have not seen this data. We have not been able to analyze it. In public testimony, we heard from one person, Susan Margolis, that there's actually been a decline in the number of registrations in the subject district. I don't know where that's coming from, but I think we need to understand that. So that's why I would like to ask for information that shows us registrations pre-passage of O2619 and post-2619. How are we going to know what the impact of the legislation is if we don't do that kind of measure? I do think that there are that the delay in the contractor, Granicus, has been quite significant, so that they've only recently begun collecting data. I have no idea what that looks like. I would like to see what it looks like, and I think we need to understand that before we make a decision about doing a moratorium. I think calling the moratorium temporary when you're pegging it to the comp plan, which can go on for years yet, is both dishonest but also unnecessary. If you want a moratorium, do a moratorium for 6 months. Do a moratorium for whatever time period you think you need. I think Mr. Manessa told us that some of the data we want to look at is quickly available. So think about it for 6 months. But let's do a moratorium on everybody. Everybody has these concerns. It's not just C1 and C1A. If there are impacts from this, and we did hear testimony back when we were doing the whole ordinance about a lot of communities that are worried about this impact. So if we need a moratorium, the other reason for a shorter moratorium is, Mr. Ledoux pointed out, is these are annual licenses. That we can stop issuing the licenses anytime we want. I think that the legislation has some inconsistencies in between the first be it resolved and the third be it resolved, which we can get into when we do any kind of redrafting. But I think that the thing that bothers me the most is I keep reading between the lines here that what we really want is a redo of the ordinance that we just passed. And that what we really want is to not have short-term rentals in the C1 and C1A districts. And that legislation has already been passed. That decision is made. And so if you want to do new legislation to change the code, do new legislation to change the code. Don't do it under this subterfuge of a so-called temporary multi-year moratorium. If you don't like the code, you can always draft new legislation to change the code. Now, the last thing I'll say is to Ashley Leonard, yeah, I definitely want to hear the answer to a lot of these questions that Mr. Ledoux raised. I do have some real concerns about, and I thought that was the reason, one of the reasons why when we did the original legislation, we didn't make distinctions between owner-occupied or residents and non-residents. And I think that if we're going to do a moratorium, let's do a moratorium. Let's do a moratorium on everybody, no matter what their ownership or what their occupancy is. And if a moratorium is warranted, which I don't believe it is, I think we can do all the analysis we need to do now, getting the information that I requested from Dr. Nash and that John Manessa just said is something that can be put very forward. But I really seriously question, why are we doing this? What is it we want to do? I don't see how the moratorium relates to the inventory and the analysis of the inventory. I don't see anything that says that we can't start right now looking at the data, looking at the pre and post passage of the legislation to see what the impacts of the data are. And remember, when we're doing a moratorium, we are taking away people's rights to use their property. And that should not be done lightly. And so I really don't see the need for a moratorium. I do see a need for analysis. I fully support that. We promised that when we passed the legislation. We said we were going to have to come back after it was implemented and we'd had some experience to see whether we got it right. We may or may not have gotten it right, but I don't think that requires a moratorium to do that. And I really don't think that we're being honest with what the real purpose of the moratorium is. And I don't think that we're using the moratorium in the correct way to get an analysis of the impact of the legislation. I'd like to see the data. I would like to see regular reports. on the data as it comes in from the company. I'd like to know what's happening in Ward 8 with the data, and I'd like to see how what's happening in other wards. So those are my preliminary comments.
Alderman, is that a motion to postpone action?
Oh, I will definitely make a motion to postpone. We have to get some data, and we have to get some other clarifications. We need to get some legal clarifications. I think we need to, I don't even know what is the definition of owner occupied, and what does that mean, and why is that relevant? What is the relevance? I've heard Alderman Tierney say, these are investment properties in a very pejorative. I bought my house as an investment. It is one of the best investments I've ever made. So let's not be pejorative about residences as an investment. It is a major part of most Americans' wealth is their home. So, you know, I think we throw around terms very loosely and very pejoratively, and I don't think that we should be doing that. So yes, I would definitely, at the appropriate time, make a motion to postpone because we need both data and legal counsel.
I think we are running out of time, so I think this is the appropriate time. Is there a second to that motion? Hearing none, I will second that motion. I'm going to call on Alderman Savage, and then I think we have to be finished by 5 o'clock, 6 o'clock your time. Yes.
6 o'clock.
Okay, so we've got 5 minutes. Alderman Savage, you're going to be the last one.
Okay, I'll try to be quick then. Thank you, Madam Chair. So again, I just want to again point out the legal memo from the law office, which was helpful and didn't raise any kind of, that I recall, any kind of concerns about this legislation. We need to keep that in mind. But also, just to reiterate, this is a pause. We do want to get some better numbers. You know, we've seen some of the numbers, again, the preliminary numbers in the staff report, and they really clearly need to indicate that there is a problem with, again, 80% of the new applications coming to these two zones in this one ward. And so, yes, I want to get the data, though, for how many active and unpermitted short-term rentals we have throughout the entire city. But I think we have enough here just based on the information we've been provided. Again, shows there's a problem in Ward 1. And so I guess part of that comes down to what your as Alderman Arnett mentioned, what do we mean by owner-occupied? And I think we've been over that, and I think your legislation defined owner-occupied. But it also, the point is that these homes, they're entire homes that are absent. Nobody lives in them. It's just visitors to the town. They're not bringing with them those benefits that you have by having actual neighbors who get to know each other and build that community. And we saw from some of these unofficial inventories that some of these blocks, these streets have a significant amount. What was it? Four out of every around half the homes that are long-term, owner unoccupied short-term rentals. So there's definitely a problem here. But I think we do, when you're talking about being dishonest, I think it's a bit dishonest to ignore what our comp plan and our codes say about these two zones, the conservation districts, and not to give us time to make sure we do get the data, because we shouldn't be issuing new permits, really. I've said that's why I was one who tried to introduce the moratorium, the full moratorium on the entire city back last year. So again, I don't think this is trying to redo past legislation. We're trying to respond to the concerns we've heard. At the time, we were said, this shouldn't be done for the whole city. Well, okay, here we go. We came back, and Alderwoman Tierney just introduced it for her ward, right? So I think we need to be respecting that. It's only focusing on those two zones, and again, only her ward. So I think we also need to understand, I guess I don't understand what the ulterior motive is that Alderman Arnett is alluding to. been pretty forthright about where I'm standing and why I'm supporting this. But in any case, I'm just to end with this. I do think we need to keep in mind aldermanic courtesy. Again, it was brought up in the past that we didn't want to do this for the entire city. This is an alderwoman who is saying that this is a concern from her constituents, and we know it is. We remember all the testimony. She's trying to respond to her constituents, and I think we need, and it's only going to impact her ward. I think we need to respect that. I think if either of us were going to do something like this for our ward, I'd hope we would each give us that respect. This is her trying to do her job as an elected official, and it's not going to be impacting us. So I just don't think it's appropriate for us to be stepping in and objecting to this to the level that I'm hearing. So with that, I guess I'll end my testimony. Thank you, Madam Chair.
Thank you, Alderman Savage. Alderwoman Tierney, I'll give you 1 minute. We're down to 3 minutes before this has to adjourn.
Yeah, with due respect, Alderman Arnett, I'm extremely upset, I guess is the word, and very disappointed in your comments that you're assuming that I have any ulterior motive in this. And I didn't think I'd have to say this, but I don't have any vendetta against short-term rentals. I don't like people displacing their vendettas on me. I have other more important things to think about. I am strictly protecting the code definition of C1 and C1A. And I'm insulted that you think that there's any ulterior motive. And the other thing is, yes, I'm very receptive to having it be a 1-year moratorium so that we can answer these questions. But the reason why we need the moratorium is, again, as you see in the staff report, the licenses are coming in. The trajectory is increasing. So this is a pause button. 12 months would be fine. I wanted it to be a date certain so that it would allow my residents to have input to the comp plan on what they want the future of these neighborhoods to be. Again, it's what do we want the future of these neighborhoods to be? So thank you for your time.
So I'm sorry that you're insulted, but I think the fact that you're discriminating between owner-occupied and non-owner-occupied says to me that there is an intent there. The legislation, the discussion I heard when we were hearing the legislation, owner-occupied is much more like a bed and breakfast. It's not like an investment property where people from anywhere in the world. One of the things we did in the legislation was we limited it to 1 per person, no matter where they live. And part of that was because of the advice we got from the city attorney. We cannot come up with these differentiating categories. I don't know that this is higher, that there's a lot more going on in C1 and C1A now than there was before the legislation, because we don't have that data. So at a minimum, let's get the data. And I don't know what Susan Margolis was talking about, where there's a reduction in the number of registrants over past precedents or the number of people doing short-term rentals. But if there is, and she used the term 400 people who are not registering, that sounds to me like the legislation is doing what it was intended to do, to not make this wholesale across the city where everybody was being driven out by investment people. So let's get the data, let's do some analysis. And I'd like you to show me in either of the last 2 comp plans where the comp plan talked about short-term rentals, because I couldn't find it. I don't think that was part of it.
Madam Chair, I apologize. We've got some technical issues and we have to be off.
Okay.
Okay.
Move we adjourn.
We have a motion to postpone action on R61. All in favor, please say aye.
Aye.
Aye. No, for the record, the vote is 2-1. Please note that we got quite a bit of testimony, written testimony sent to us by email. So I would ask you to refer to that testimony so that when we have another discussion about this, you'll be aware what the community is saying. I'll now entertain a motion to adjourn.
So move.
Second.
Second. All in favor, please say aye.
Aye.
Thank you very much. And sorry, Julian and Mr. Lyles, for going 1 minute over.
Good night, everybody.
Night.
Take